Okay, so good afternoon, everybody. How you guys doing? Um, well, I believe that. Can you hear me? If you can hear me, please let me know. If you can hear me, please let me know in the comment section. I can hear me, so I can proceed and just move forward. If you guys can hear me, please let me know that you can. Okay. Okay. So there's a Stephanie Asuga, I believe. I don't know if I pronounced that well. I'm sorry if I did not. So, who said that she can hear me? So I'll just proceed to what I'm talking about today. So, a lot of people messaged me. For those who do not know me, I'm Olayeni Dear Kolola Daniels, or for short, like everybody will call me, Dear Kolola Daniels, right, or Dear Daniels. Now, somebody messaged me, and not somebody, a lot of people messaged, and they're like, law school is this, Dieko, law school is that, save us, do this. Like, when I mean save us, I mean like, what should I do, how should I go about it, blah blah blah. And I was like, okay, just you guys just chill, right? um after law school, I had Kotuba. Then after Kotuba, I had NYSC camp. Then after that, we resuming at the workplace. So it was just from one thing to another, to another, to another. So I didn't have time to hold sessions like this. But this being a little bit more comfortable, I said, you know what, let me create a session for law school students. So I know that a lot of you are very confused, right? Especially these new sets that started. You know that 2024 law school decided that they want to do the normal set. Then there's now a new set. I think May, or they started May or thereabout. They want to do a new set to what is it called? A new set to offload the backlog, right? So that there wouldn't be more people waiting for law school and all that. So these new sets that they just admitted, they are very, very confused. So I am going to be speaking, right? I'm going to be speaking on law school, and I'm going to try to make sure that as I'm speaking, I carry everybody along, right? I tell you the things that you need to do. It's not something I can speak about in 1 hour. This is supposed to last for 1 hour. It's not something I can speak about in 1 hour, definitely. So I'm going to try my best to make sure that I cover areas that you need. Do you understand? So I think that when you are going to law school, the first thing that you should understand is that there's a difference, a very big difference between law school and other, where you are coming from, right? The university that you're coming from. Law school is crazy. That's the first thing. Law school is extremely crazy, right? One thing that you need to understand is that at law school, what you deal with is procedure. You don't deal with substance. So most people go to law school and they are like looking for substance to learn. You want to learn the rule in Rowlatt and Fletcher. You want to learn land use act, like the substance of land use act, trying to be jurisprudential. Comparing jurisdiction. They do that kind of thing for law school. For law school, it is procedure that you are basically coming to learn. Do you understand? So, how do you file an action in the magistrate court when you see a case? What court is supposed to have jurisdiction, right? What is the procedure for filing that case before that court? I'm talking about civil litigation now. So, if you see a case, right, you should be looking at monetary jurisdiction. If it is more than 10 million, then it's likely to be the high court. If it's less than 10 million, it's likely to be the magistrate court. When you get to the magistrate court, what are the ways by which you file an action in the magistrate court? There are two ways, either by claim or originating application. Look at the case. Is it such that the matter is contentious? If it is contentious, under claim, you have summary summons, you have ordinary summons. Do you see the way I am going? That is what you are supposed to, the things you are supposed to learn at law school. Now, but let's suspend that. Now, let's now go to class. And when we are talking about when you get to law school initially, you know that the first week that you get to law school, everybody is still flexing. You are going to look for your food spot. This is where I want to be eating now. You look for 2 to 3 food spots that you'll be eating after class. The next thing that you want to look for, probably the church you'll be going to. The next thing you want to look for, that 1 week everybody's chilling. You're meeting new friends. You're shining teeth. Just wait. Very soon that your teeth go start to shine out. You go start to complain. By the time you enter the first class is still understandable. Everything is introduction. Under criminal law, they'll be teaching you, you have the ACJA, that's the Administration of Criminal Justice Act. You have the ACJL Lagos for Lagos State and Southern Nigeria. You use the ACJL Lagos for any case that happens in the West, in the South rather, and then you use the ACJL Kano for anything that happens in the North, and you use the ACJA. That is, when I say anything, I'm talking about problem question. If you see a problem question on criminal litigation, and once you just see Zamfara, what you are using is what? ACJL Kano. If you see Ogun State, what you are using is ACJL Lagos. This is because it is not possible to teach all the ACJLs. So that's what you'll be taught in your week 1. So week 1 is usually fun. Okay, this is not hard. By the time you get to when you're also in a civil litigation week 1, what is ADR, what is negotiation, what is mediation, what is introduction to civil, everybody's like, this chill. Then by the time you start taking the step, I think the class that might stress you a little bit, at least for me, it stressed me, was corporate law. From week 1, that's when the woman, she just entered class. I would do better than him. But if you went rather to Port Harcourt Law School, or you go to Port Harcourt Law School, you would know the person I'm talking about. And she just entered class like this. Everybody draft a memorandum of association, first class. In my head, I was like, it's like you people did not understand how this thing work, right? I am coming here to learn. So which means that for me to be able to draft the memorandum of association, you first must teach me. Then I will look at what you have taught me. Then I will not learn it. Do you get? Now I will not be able to draft it. But law school said, nah, that's not how we roll here. Here, you ought to have known that you will not come to class. Then we will not try to instruct you by telling you, that's not how you do it there. So you must have tried it before you came to class. It was corporate law that taught me that. Then you have property. Property is very chilled. They will just be, what are the laws we have in property law, and where is it applicable? In what transactions are these laws applicable? Then ethics. Ethics. That one you just be chilling, very chilled. So in your week 1, you are. By the time you get to your week 2, to your week 3, to your week 4, to your week 5, and then by the time you now start understanding that class will start by 9 a.m. every day and end roughly by 3 p.m., save and except Lagos Law School. Those was, I would not comment because Lagos Law School, they used to do overall best in academics for some reasons. They are overall best in academics. So, but for Port Harcourt Law School, even in Abuja, I think they end at 1 or 2, I don't know. But for Port Harcourt Law School, we end at 3. Maybe at worst. In some corporate law class, and it's corporate law, you end at 4 o'clock. So you start understanding that when you go to class at 9 o'clock, then you come back from class at 3. You know that you have had about 6 hours of intense learning, and it is one topic that they teach in every class. And you have 5 days in a week, right? So they've taught that one topic. The moment they teach you that one topic, the next time you see that one topic again is in exam. So if they teach you magistrate court, which I think is like week 3 in civil litigation, the next time you see magistrate court again is in exam. If they teach you commencement of high court, the next time you see commencement of actions in high court, the next time you see that again is in exam. If they teach you pleadings, the next time you see pleadings again is in exam. If they teach you charges, so if the next time you are going to interact with this thing in relation to lecturer again is in exam, you try to grapple because they've taught you, Abi, you are expected to know. So okay, you are in week 1. Let me try to hold the information in week 1 and see if I can juggle with it. while I'm entering week 2. Week 2 came, they bombarded you with a lot. Let me try to hold information in week 2, and then let me see if I can grapple with it before I get to week 3. Then we get to week 3. Week 3, they knock you again. By the time you get to week 4, then you're looking at yourself. Wait. Week 1, I never understand that. Wait. I never put that for head. Week 2, I never understand. Week 3, I never understand. Week 4, I never understand. We don't do week 7, week 8. I am lost. And then because of the accumulation of the classes, you are like, hey, Jesus. Law school people want to kill me. Law school is not for me. Jesus Christ, where is sniper? I want to drink it. Calm down. Like, do you get? Just calm down. Now, if you are going into law school, and also when you look at the methodology of teaching, law school does not teach you. They don't care about teaching you. It's, according to what they will tell you, it's a vocational training, you know. They are there to instruct you on what to do, not necessarily to teach you. Some lecturers are passionate and will try to teach you. But even if they want to teach you, there is no way they can teach bulky topics in one day to the best of your own understanding. Do you understand? It's something that, you know, that when you were in the university, if they are teaching federalism in constitutional law, for example, they can take 2 to 3 weeks, depending on how lazy the lecturer is. The lecturer will come, he will just teach one part, he will go, he will come back again. Still dancing federalism, teach another part, he will go, he will come back again. Do you understand? Depending on the lecturer, right? You can go and come. In law school, there is no go and come. Once that teacher says, and we shall call it a day, you see, the next time you will hear that a day again in that topic is in the exam. Do you understand what I'm saying? So you need to be, I'm actually very serious. You need to be very, very careful, and you need to understand the tricks of law school. Passing law school itself is not by, another thing I've noticed from students is that, you know, I'm trying to like introduce you to the reason for all this shalaye that I'm going to be shalaye today and other days, right? You know, when you get into school, for example, someone like me, did I bring my agaba here? I think I have one agaba. Just give me a minute. When you get to, hey, Jesus, my books are piled up. Let me see if I can just remove the agaba out of it. Yeah. Okay. Good. Now, this is what I used for criminal litigation, right? This is agaba on criminal litigation. I think it's the latest edition, right? Now, some people, you can see how big this book is. Some people will carry this book. They want to do, I am the best in criminal law, and start reading every single thing that is inside. My dear, you will crash. You want to form hard work, you will crash. They will carry agaba on criminal litigation. They will carry agaba on civil litigation. As bulky as it is, they will carry... No, it's not like that. Do you understand? Now, let me talk about classes for today. As we go in other days, I'll be talking about some other things. And if there are questions, please put it in the comment section so that I can answer your questions when I see them and try to like direct what I'm saying. Now, when you are going into class, for those people who are new, fresh law school students, and I was trying to talk about externship as well before I leave. When you are going into class, you are supposed to read the topic that you are going to. You don't know anything about that topic, frankly. And I will not even advise you to read this one. You see this one? Don't read this one when you are in school. Read it during externship. You get why? You actually get why. Where is the one that I used for? Okay, I can see it here. Yeah, just give me a minute. I like buying books. I don't used to do Condi Smith and all these materials. Oh, sorry, my ring light went off. Okay, good. Now, this is by Afolayan. He passed away when I was in law school, right? May he so rest in peace. He was the one who wrote this book. Now, you can see how small it is. That's why I like it. Because it is small. So, now, let's say, tomorrow, we're having what topic in criminal law? Let's say, charges, right? No, the one before charges. Commencement of actions. Commencement of criminal, is it institution of criminal proceedings or something? I can't remember the name of the topic, but I think it's institution of criminal proceedings. So we're having institution of criminal proceedings. How do you institute an action? Who institute? The state institute. What is going to be the party? The state of Lagos, if you are in Lagos, versus the defendants, right? You know, and if you are not in Lagos, it is the state versus Do you understand? You know, there's a difference between an information. If you are drafting in Lagos, you use an information. Also in Abuja, you use an information, but you can also use a charge in Abuja. But if it is in the north, what do you use? You use a charge, right? That's under charge. But I'm just talking about institution. We're not talking about how to draft a charge. We're talking about institution of a matter. It is the Attorney General of the state that institutes a matter. However, there are certain exceptions where through a fiat, a legal practitioner can institute a matter. Not just the Attorney General, there are prosecutorial agencies also. NDLEA can institute a matter if the matter is concerning drug and it comes from the NDLEA Act. EFCC can institute a matter. So if you understand what I'm talking about, I'm just saying this is institution of proceedings, right? Good. Now, you see this book. The day before the class, I carry the book and I will go through it. Let me not be lost, because you see, there are some lecturers from the beginning, as you're entering into the hall, don't worry, you will know those lecturers. As you're entering into the hall and you just hear his voice, you just know that you are done for the day, because you are in that class to sleep. You will not, so far you did not read before that class, you will not understand what the lecturer is saying. So you just as you just sit down on your seat and there's always AC around, you just do like this and then you sleep off, because what the lecturer is teaching, you can never get it. So what you do is that you carry this one, you read, you open it, you read that topic. See it, it is here. You read the topic that you want to go to the class for the next day. It's small, so you can just carry it, 10 pages. Even if it is, I'm tired, you just have to read it before. This is if you want to get your AO. You know that I'm talking about students that want to pass and students that want to get A. There's a difference between pass and get A. You can read sharp and pass, but I doubt you can do that in law school. But if you want to get your A, now there's a difference between getting A in a course and getting overall first class. What I'm talking about is getting A in courses, right? So if you want to get your A, you carry the what is it called? The course, right? You read it. Don't carry the hefty ones. Imagine you two, you want to carry this one and read it before the class. Would you slip off if you carry this type of thing? You that you had 6 hours class on that day, and you want to revise on the 6 hours class, at least not one or two things. Won't you slip off? Is this not too big? So you don't use this one. There's a time for this one. You keep it. Then you not carry this one. You read it before the class. Then when you get to the class, you've underlined as the mind is talking, because you have read it. As the mind is talking like this, just be underlining. Okay, he talked about this part. He talked about this part. This part, he didn't talk about it. Let me write it in my notes. Look at the lecturer slide. They didn't talk about it. Let me write it in my notes. Do you understand? Now you are beginning to tailor your reading to the parts that the lecturer has taught. Note that for the sake of law school exam, it is not everything that is inside this book that you are going to read. You will run mad. You are going to catch fire. Secondly, carry the handout. They call this the handout? Handbook. Carry the handbook. Go to the, what do they call them? Content. I've been waiting that thing where they always talk, say, outcomes, yes. Because they will always go to the outcomes. This is civil, this thing, so it's not the same as criminal. So go to the outcomes, right? Look at it. What are you expected to know in this topic? That is what you are reading. Look at those outcomes. But don't start with the outcomes before you go to class. Do you realize they don't start with the outcomes? Because it might be somehow, it might be confusing. You know, you just finish one class and you're going to another class. So what you do, you pick your book, you go through that topic. Just when I say go through, you're not learning, you're not putting it in your head. You are scanning, right? As you're scanning, you're trying to understand. If there are points that you don't understand, that is the point you start noting it down. What do they mean if you want to have a special court? I think special court is for 4, right? Special court martial is 4 or something. General court martial is 2. What's the difference? What are the kind of cases? You start noting your questions down. You might not necessarily, if you're a shy person, you might not necessarily stand up in class and say, hey, my lord, lecturer, I want to ask questions. After the class, you can go and meet the lecturer, but we'll get to that. Right? So what you do, you read through the question, you read through the notes, you say, yes, okay, I've read through the notes now. You write down your questions. If the topic is too bulky, right, that it might be difficult for you for you to read through. That's when you now look through your this thing. What are the outcomes? Try to see which part you should read through before the class. Or you can ask for class slides of last year. Look at the lecturer's class slides for last year. Then you will now use that one to read through. If it's too bulky, if it's not too bulky, you can just scan through and note. When you now get to class the next day, you now start listening to the lecturer. Do you understand? Okay, the lecturer mentioned this, you write it down. The lecturer mentioned that. Someone said, James, explain why you sorry. I don't even understand. Oh, okay, James. Oh, James KWG, explain why you are this lively. I think that's what you want to see. But don't mind James. I can see James in the comment section. Don't mind James. James was my roommate. He's a big man who working in big firm now. Banwa and Igodalo. You are welcome, sir. Very, very welcome. So as I was saying, so you write down what you are supposed to learn for the. I think I'm beginning to sweat. Please, 1 minute. Let me put on my fan. I did not put it on before. The battery is low. Let it charge a little bit. So yes, as I was saying, so when you now get to class, you understand, because you have read what it is that you wanted to read. You will go through it, right? And then you listen to the lecturer. Then when you do not now have a question, you then go to meet the lecturer so that the lecturer can explain that question. Then you now go back home to read. Now, this is where you can now start having a problem, because you are done with class at 3 o'clock. And you are expected to read the one that they just finished teaching you. You are the same you with that your small head. You are still expected to read for the class that is coming. Do you see the reason why you cannot play in law school? Now, when they say read for what you have done, they are not saying that you are supposed to know what you have done. This is what I believe. You are supposed to note it down. Do you understand? Someone said, following from Kenya, Scott Legal Channel, you are welcome, my Kenyan friend. How are you doing? After the live, I guess I'll follow back. So as I was saying, you are not supposed to carry it in your head. That doesn't mean that you will not know what they taught to, and if they ask you, you still cannot answer. But it is not everything that you are expected to carry in your head after you are done with class. You are just supposed to know. Right now, also, there are some topics for criminal litigation. You don't have a lot of drafting, but for civil litigation, you have drafting. There are some topics that you are supposed to have drafts for. Magistrate court, you will draft claim and particulars of claim. The day before the day for magistrate court, you would have looked at the draft for claim, try to draft it, right? So that when you go to class the next day, you can ask your lecturer, did I draft it well? You buy a draft book. I use the one by Agaba, right? I don't think there's any best draft book in law school. What you have your own draft. Try to make your draft. Go to the lecturer and go and ask the lecturer, Ma, is my draft good? Then your lecturer will look at it, make some correction, go back and do the correction that your lecturer has made. Then go to the lecturer again. Is my draft good? If the lecturer says, okay, that is the draft that you begin to practice for the sake of the exam. Do you understand? When do you do that? You do that the day. So when you are hearing that, okay, the next day, which class? Not that most of all these things I'm saying, I learned them in third trimester. That we have 3 trimesters. The 3 months before externship, then the 3 months of externship, and the 3 months after externship. I was as confused as you are in the 3 months before externship. I was reading, in short, I didn't even know that there are 2 drafts in criminal litigation: charges and bail application. Those are the only 2 drafts that we have. I didn't know that, and that now underscores the reason why you need to be studying past questions. There are so many things to talk about, but let me take you one after the other. Now I'm still talking about class. I'm not speaking about past questions. So now it was when I came back from law school that I said, from externship, that I said, Jesus Christ. I didn't start this my reading well, because I was reading every and anything, drafting every and anything. So for example, under warrant, I learned how to draft this warrant now. I learned how to draft arrest warrants. I learned how to draft summons. My guy, those things were just useless. And how did I know? Because at the end of the day, when I started using these things that I was saying, okay, let me take my draft, let me take it to my lecturer and ask my lecturer for corrections on my draft, whether or not I drafted it properly. My lecturer just looked at me and said, what is this? Arrest warrant. Why are you drafting the arrest warrant? Who sent you message? The only two things that you are going to draft in criminal litigation, charges and bail application. After that, there was one question in the past question when they said they should draft letter to legal aid that requesting for a lawyer for somebody, an accused, right? It really seldomly comes out in criminal litigation exam. But please practice your past question so that when you see it, you can know how to answer it. So moving on. So it was because I drafted and I went to meet the lecturer, and the lecturer said, no, you don't need this. The only thing you need is the content of an arrest warrant, right? What are the things that ought to be there? The crime that the person has committed, the issuing authority, the judge, right? The issuing authority, the crime the person has committed. Waiting the arrest warrant again. And I cram out for law school. I can't remember. I think dates. I can't remember, but you get what I'm talking about. For those of you that have read, if you have not read, that you're in my situation, me, I'm done from law school. I had my A. You are not in the same place, so make sure you read. Do you understand? But that's just on the lighter notes. So at this point, you're supposed to know, especially if you're on externship, and I ask the question and you're looking at, hey, waiting in the content of an arrest warrant, you're supposed to know. Do you understand? But if you are still in law school, like the first trimester, then it's excusable. Now, but moving on. So what are the content of the arrest warrant? Those are the things. So the more you are going to make a lot of mistakes, and then you run to your lecturer, sir, please this. We say, who sent you to read this one? Better, do you understand? That is how it works. That is the reason you have to read before class. Then after that class, you go and meet the lecturer. You ask the lecturer if they are draft for the class. You ask the lecturer, and you see from your outcomes. From your outcomes, it will tell you that there's supposed to be a draft. You are supposed to know how to draft. Do you understand? So you ask the lecturer, look at my draft, is it good? The reason why you need to ask the lecturer is that there are discrepancies between draft book. What you will find in this book on how to draft a charge might contradict what you will find in this book, Agaba, on how to draft a charge. And the most superior authority on drafting of charges is your lecturer's words. Do you understand what I'm saying? So when you go and meet your lecturer, please, is it correct? Is it not correct? Your lecturer will tell you, this is how you ought to have done it. This is how you ought to have done it. You go back and meet him again. Is it correct? When he now says that this one is correct, you carry this one, you go and put it somewhere. You learn it, then you know that you cannot keep learning it every day. There are other things to learn. Go and keep it somewhere. That's your 1 month to exam. You see these ones that you have been accumulating from your first week to your last month to exam, you will now bring them out, because those are the things that the lecturer have talked about, that this one is good. That is your own draft book for exam. Do you understand? And how do you start accumulating this your draft book? From the first day of class. You will not wait and say, no worry, don't worry. We still have about 9 months in law school, my dear. You see, law school, the way law school time used to run, the way law school time used to run. Oh God, but that's not what we're talking about. So regarding reading for class, because that's the question, there was one girl that asked me that question, I think on Instagram. Regarding reading for class, I hope that you have known how to do it. Now, when you come back from class, what I used to do, right? And my roommate used to be very, very angry when I do it, because I don't like sleeping with the light on. So when I come back from class, I will first off lights, or chop first to comfortably, look for, there was this Hausa people that were selling tuwo, and these Yoruba people that were selling amala on campus in Port Harcourt, right? So I'll come back from class, either I eat tuwo or I eat amala. You know when you are back from class, you are very hungry, you need something thick, not all this rice and indomie that people, I will see girls eating boli. When hunger is holding your stomach, when you get, after you finish eating very strong food that will hold your stomach very well, then you now go and lie down and sleep a very good 2 hours sleep. 2 hours, it shouldn't be more than that. Sometimes it used to be more. There is a way you'll be tired that as you want to start up, your body will say, yes, sleep back. You are tired. Please sleep. And there are some people started overnight, first week, second week of law school. Please, it's not that deep. Sleep well, because it is what you hear in class right, that will form your notes to read for exam. So you need to pay attention to your lecturer speaking. Do you understand what I'm saying? Some people will go for overnight. I don't know who is telling you to go for overnight. You are still in first trimester. You are not even close to exam. Even if you are close to exam, overnight is a big no-no, right? So, well, I don't. Let me calm down. Now, moving on. So, sleep well. I'll sleep for 2 hours. So, let's say I get back from class by 3. Then from 3, I will sleep till like 5, 6, right? After eating 4 to 4 o'clock. By after 4:30, I'm already asleep. By 6 after 6:30, I've woken up. I've carried myself. Oh yeah, to class, right? Then when I get to class, what I sometimes do is that what they've taught, I already have looked through. I know the points that they discussed in class. I will try to note those things down. For people like me that like writing notes, let me see if I can get my law school notes for you. Just 1 minute to show you how I used to write notes. My daughter. Okay, so moving on. Now this one note. There were a lot of notes. You see, I don't read them deep. The whole face don't come out. So this is like my course outline. I wrote it in front of my notes so that the next class I already know that this is what I'm going for the next class. Now you can see this is like I wrote notes. When it comes to writing notes, there is this, right? This where I put all topics in one paper. But this is something I'm going to talk in another episode. I can't speak all of them. I have 30 minutes left. So I'm teaching you how to read, right? So you can see this is week 1. Wait a minute, this. I think this is the names for something in our group 6. So yeah. So now you can see this is my criminal litigation notes. This one is even one note. There was something I was doing. I used to write my note on one side, then I'll read the other side vacant, so that in case the lecturer wants to say something and I need to note it down on that issue, I will not write it down here. But this thing is really time consuming and I will not advise it for law school. I would not, because at some point I was regretting I was writing this much, right? So there were lots, right? I'm just trying to let you know that I wrote notes. For those that are note writers, I would not, that if you are going into law school, I would not advise you to change your reading plan, right? So if you are a note writer, I will not tell you to not write notes, but I'll tell you write notes with wisdom. Write notes with wisdom, because there's a way you write notes that you begin to waste so much time from law school. Do you understand? So please write notes with what? With wisdom. So as I was saying, so when I got back from class, what I'll do is I'll pick up the notes that I wrote the day before, try to read it, and look at the points that lecturer has made. Just pick up 1 or 2 points from it. I can't know it at that point. Then I will now pick up, that's in 2 hours. So from 6 to 9. By that time, shops are already closing. So I'll quickly go and look for Indomie or bread or something to go and buy. Then I'll come back and then I'll read the next class, read it to 12 o'clock, right? Then I will now go back to my hostel. I can't read in my hostel. Some people that used to read in their hostel, those people have supernatural powers. I can't see bed, see fan, and then I'll say that I'll carry book. It doesn't work for me. I have to be in the class where I'm more comfortable. That's when I can read. Do you understand what I'm saying? So then I anymore, but there was something I was expected to do that I didn't do. Please, if you can share me, put it in the comment section that I can, so I can continue. How do I do this now? I have to start doing structuring and it's going to be quite difficult. Yeah, I think this is better. If you can you hear me? Please let me know if you can. Okay, Maria Chikamso. Ochi said I can hear you. Okay, so yeah, we can continue then. I'm so sorry for the break in transmission. The phone hot, iPhone something. So there was something I was supposed to do before that, which I didn't do, and that's the reason. Okay, so moving on. I hope it doesn't start its madness again. Let's pray it doesn't. What was I talking about? Hi, Jesus. That's why I don't like my train of thought disconnecting. What was that? Okay, I think I was saying something along the lines of when you. Someone said I can't hear you. I hope you can hear me now. Chuku. I want to believe this is modeling, right? Modeling. I don't know how to pronounce it. Okay, but moving on. Something about showing us notes. Oh, okay, yeah. So I was saying, like, in relation to the notes that, please, I wrote notes, but it's not advisable. But just make sure that when I stand up and I go to read in the class, I try to look at what was taught by the lecturers first for that day, not because I want to cram it. I keep saying that at that point, if you can't cram it, it's good, but that point is information overload, because you have 10 weeks straight of learning a lot of things, right? So I wouldn't advise that you start cramming at that point, but know what you are being taught. Know it. There are some things that are notorious that you will cram. Some things are just notorious that you will cram, right? That you will know, right? But all those nitty gritty and all that at the beginning stage is not so. That first 10 weeks before externship is not so. Sure, you get. Now, when you are done with that, then you now look at what do I have for the next class. Make I read them. Once you don't read them, you don't underline some parts, write out some parts where you don't understand. You look the draft for outline. They say, oh, draft this. You don't carry your paper, right? I used to use A4 paper, something like this. I bought a whole pack, so I used to use this as my draft papers, right? So I'll just pick a new paper, draft of, let's say, summary summons. I'm just giving an example. You don't need to learn the draft of summary summons. The only thing you need to learn for summary summons is the letter that serves as an application that must be attached, because if you don't attach an application for summary summons, it's an ordinary summons. Do you understand? So I think it's the letter that you need to learn how to draft. After the letter, then in short, it is the claim particulars of claim, and your payment of your filing fees. Those are the three things that you institute an action when it comes to magistrate court under claim. It's an ordinary summon if you don't attach the letter. It's just your claim, particulars of claim. When you now attach the letter that this matter should be by summary summons. So for summary summons, you need to learn how to draft the letter. How do you properly draft the letter? Who do you address the letter to? What is the heading of the letter? What will be the body of the letter? Who signs the letter? Those things you can learn it. Let me write it down, blah blah blah. You draft, you go and meet your lecturer. Your lecturer will say, when you are signing for the lawyer, it is not the firm that comes first, it is the name of the lawyer that comes first, right? Then what comes next? The firm comes next, then the address of the firm, or your address, then then your email, then your phone number. If it doesn't go in that line, you have lost one mark. You see, you've learned that like that. Do you understand? I know this because my lecturer said it. I think I didn't put, was it phone number or something, or email address. As little as email address in that place, you've lost one mark, because they read it as a whole. In practice, it might not affect you, but there you have lost. How will you know that? Because you drafted it and then you went to go and meet your lecturer. And sir, please guide me on this. And he will tell you this is what to do, this is what to do, this is what to do. Do you understand what I'm saying? So once you are done with that, then you go to class, you repeat that same routine again and again and again. Read before you go to class. When you come back from class, sleep, read. Not read to memorize, but read to, again, emphasize what the lecturer spoke about in class, what you read previously. If you've seen that you've gotten a grasp of it, if you don't have a grasp of it, write those parts that is confusing you. Go and meet your lecturer the next day. Lecturer, for that thing that you taught this day, I didn't understand this part. He will tell you, this is what I mean. This is what I mean. Okay, now you've gotten a grasp of it. The reason is you are creating a right foundation for externship. You have 3 months for externship to read solidly. Do you understand? To memorize, to solve past question, to fire down. Do you understand? That is for this thing. But what do you read during that time if you did not understand it when the lecturer was teaching? You didn't understand. You were just looking at the book. You don't understand what's there. By that time, you now want to start reading to understand. You are wasting your time, because that time is no longer reading to understand. It is now reading to stick, to know. That is your reading to know. In the beginning, it is reading to understand. Let me even know what they are. Pleadings, but pleadings read. I've not heard pleadings before. What's pleadings? Okay, we have statement of claim. We have statement of defense. We have reply. In normal institution of action, okay, what are the rules guiding statement of claim? You don't know them, right? So you are just hearing them for the first time. You are reading it before you go to class for the first time. Okay, when it comes to there's the writ, right? If a claim is stated in the writ but it's not stated in your statement of claim, it is deemed abandoned. But if it's stated in your statement of claim but it's not stated in your writ, then it is proper. You know, those kind of little things. You are okay. That means that the writ the statement of claim supersedes the writ. What is the authority for that? Enigbo or something. I can't. Enigbo versus Dieko. I can't remember. There's this authority that says that your statement of claim supersedes your writ. Where there's inconsistency, I think it's the statement of claim that flies. I think it's Enigbo or something. I can't remember that authority, right? So at that point, you are just learning what are the rules of pleadings. When you talk about pleadings, order 17 of the Lagos rules, order 15 of the Abuja rules? You at that point again, you are just learning orders. If you have been consistent with your reading, you will know that when it comes to Lagos and Abuja, they are always two behind, right? When Lagos is order 9, Abuja is order 7. When Lagos is order 15, Abuja is order 13. When Lagos is order 17, Abuja is order 15. Do you understand? They are always two difference, right? At that point, you are learning the orders. You are not learning the specific rule. Order 15 rule something, although it's not necessary to learn a rule something, so to say, except you want to be overall best in the course. It's not, you can get your A. I don't even think I wrote rule something when I had so much to read that you should see that rule. You know, there's order 5 rule 21, order 5 rule 22. I'll be reading those rules. I'll be cramming the rules. My dear, I'd rather come the order. I shall know the order. So everything you say, I just say order so of the High Court civil procedure rules of Lagos State or something. So at that point, at the point of your this time that you are in school, you are just trying to learn. I think there's a question: would the lectures after externship be bulky? It go too bulky. It should not bulky pass. Election petition in a civil litigation that you are coming back after this thing. You will face election petition. It bulky die. You will face matrimonial causes. You will face waiting the fundamental rights. That's, you know, all this. When you there here now, you did this book: fundamental rights, matrimonial causes, election petition. What else? What else is even there? Let me see if I can quickly look at it. Closing address, enforcement of judgment and appeal. Election. I shall know that it's from recovery of premise is very sweet. That one is sweet. That one will not stress you. I think those are most of the things that you are going to find in your latter part, you know. But it's bulky, right? But that's one thing that you have to have achieved in your externship. In your externship, when you are now coming back from externship, right? You are going to school. By that your externship period, you should have known the topics. You should have finished the topic. I finished the topic before I went to school. That does not mean that when I got to class I wasn't still lost in some aspect though. But I already knew motive for coming back. Like, but yes, I am coming to meet a whole lot when I get back, because I've read through. I've read mergers and acquisition. I've read, because when we were going for law school, sir, I want to know if those easy read materials are better than the textbooks. I don't want to spoil someone's business, first of all. So I will not speak as to something I did not use. I did not use easy read. My friends used it and they have good things to say about it. Me, I didn't use it. But what I can advise is that if a textbook is too bulky and you cannot scan through before class, easy read is like key points. It can give you some of the key points that you at least should know before you go to class, right? So just read through, and if you are looking at textbook and you're like, hey, this is too massive or the massive, right? You can say, okay, let me carry easy read that goes straight to the point, right? And get one or two points before you go for class. That is what. But to read easy read for the sake of exam, me, I can't speak as to that one, no. But if you are reading it to go to class so that you will not be lost if you get to class, then when you now get to class, now you now understand You can now go to your textbook and read from your textbook, read it in line with the class and the handbook. One thing I use this handbook for, this was my best friend, for the sake of authorities, cases. The cases in this handbook are they are the things in your marking guide, right? So when you are writing an authority and you want to look for a case to it, this is where you find that case, because whatever it is here is your marking guide. That's the marking guide for law school. Do you understand? So I use this one for cases. Then any case that my lecturer also give, I also use it. So I hope I've answered your question when you said that if we should read Easy Read. I cannot speak as to how good Easy Read is personally, but I can tell you that my friends told me this is hearsay evidence. However, I'm not speaking as to the truth of the evidence. I'm only speaking as to the fact that I was told that, I was told that it was good. Do you understand? So it's not hearsay. Ojo versus Garuru. You will see it in civil litigation under, I think, trial. Ojo and Garuru. Now, that's that for that. That's that for Easy Read. I don't know about for exam, but please, if you want to read it and your textbook is Zuboki, read it before you go to your class. Yeah. Let me see if there's any other question. Would you advise one to make notes, especially someone that is addicted to it? Me, addict to it pass me. I addict, I too addict. I dey write, write notes. There was a time that anywhere you see me, I'm like this. I'm just writing. I was very, very, very diligent in writing. But at some point, to write notes is not the problem. To write the right notes is the problem. Because when you're writing notes, you don't know what is the important ones and what is not the important ones. You are reading everything all together. And because you are reading both important and non-important, and you are writing both important and non-important, it's time consuming. For the purpose of exam, you now want to read. You now begin to read both important and not important. That is why in the beginning, you don't write notes. Are you listening? In the beginning, you don't write notes. You can note some things, right? You are reading a book and you just note some rules. Write it down. I am a visual person, right? More than an auditory person when I'm learning. So I learn better when I see than when I hear. So I already know myself. So I like seeing that thing. In exam like this, it will appear like this for my front. Say, yes, my notes, especially when I've been very conversant with it. It will appear, I will just when you can literally just see your note and you're writing it down. So I love when my things are written down. But there's that danger, which is where most law school students, err, and then it results in their not too good performance. There are so many law school students, tutu students. I can tell you for a fact, there are so many tutu students that first class students don't be compete. Waiting they know. If you compete. But the first class students read in lines with the rules and strategy for law school by exam. They read with practice. In practice, their knowledge is so much that they know this, but they did not streamline it in line with what law school is looking for. Do you understand? You are supposed to streamline your reading. So that is why you can see what are the guides to streamline your reading. Before you go to class, read first. When you are reading before you go to class, you are reading the whole of it. Then when you now get to class, you now say, But for waiting I read, my lecturer no mention this part. If your lecturer no mention am, no read am. Basically. If your lecturer did not mention it, and it's not here in this book, it's not here. If your lecturer did not mention it and it's here, read it too. This book is authority. But if your lecturer did not mention it, this book did not mention it. And then when you have gone through past questions, you see that it was not mentioned again. It means it's not relevant. There are ones that, especially this case, this rule in civil litigation, I'm very sure that if you are in extension right now, they would have told you when there are two applications pending before a court, the general rule is that it is the one that came first that the court will hear first before the subsequent one. However, the exception is that where one is to give life to a suit and one is to kill a suit, the court will listen to which one. Is it the one that will kill the suit or the one that will give life? The one that will give life first. What is the authority? NASA Team Associates. Hey, I know there is one. I think it's NASA Team Associates versus NNPC. Is it NNPC? It's NASA Team Associates versus something. That rule. So you see, in line with that rule, the authority is here. Do you understand? When they give you, there are some rules that are notorious. This thing I just said is likely to come out in exam. This thing, it always comes out every year. You can't run away from it. It will come out. So when you are talking about rules to learn, when you are reading, the danger of writing notes is that when you are reading, you do not know what parts to read and write. Therefore, don't write initially. You can note. There's a difference between write and note. Note is, okay, this rule, this question, this rule. Notes, for the sake of you just entered law school. When you can write is during your externship. You have 3 months. You can now strategize. Now tell yourself that, you know what? I want to use this 1 week to write 3 to 4 topics. Then, you know that another thing about your writing during extension period is that you already know, even as you are reading that notes, if you followed my strategy about reading before class, reading after class, by the time you are reading notes, you say, I can remember now when my lecturer was making a joke about this thing. This one, he talked about it. I can remember now when he said this, when somebody asked a question on this, this one, he talked about it. When you are forming your notes, you are now forming your note during extension period. You are forming your note based on those things that he talked about and based on what you can find in your handbook for the sake of your knowledge. Do you understand? That is a better strategy of reading and writing than when you are writing from the beginning, because you are writing a lot. You don't know what to write. You don't know what it is that the lecturer is looking for. Do you understand? So that's basically what I wanted to discuss today. For those people who are just getting into law school, this is your reading strategy. So I've taught you the reading strategy for entering. When you enter the first three months, these are the things you ought to do. Then externship, I don't think I dwelled more on externship. Right? Externship has its own reading strategy itself, a different caliber of reading strategy. Then when you now come back, there's another reading strategy. You can't use the reading strategy of before class, before externship, for the reading strategy of after externship. Right? So before externship, this is your reading strategy. You are reading to know. You get just to have an understanding of what it is. Right? So please, if there are questions that you'd like to ask, please ask your questions now. It's already 52 minutes, which means I'm supposed to log off soon. So please ask your questions now before I log off. And don't worry, I'm going to try to make this a frequent thing, probably on Saturdays. I will also try to talk to some first class students, like the overall best students, to join us in 1 or 2 live sessions. Where he will also talk about his experience. I don't know if YouTube does a very good live session. I might pre-record it on Zoom. So I might tell you, please write down your questions, send them to me. I will ask him, he will answer them, then I will upload. And then if there are further questions, I can have live sessions on that. Do you understand? Because of the sake of network and all those things, so that we don't get affected. If you have any questions, please ask your questions. I know that some people ask, what books did you use when you were this thing? I used Agaba for my criminal litigation. I used this one too for my criminal litigation. I used when I said I was going to do Zoom, I didn't say that I was going to do Zoom class. Everybody will be on Zoom. It's just me and him. It's just I and him that will be there. I and him. What's the correct pronoun? You people know the correct pronoun. That will be there. So you ask your questions before, because I don't want people to be interrupting. You just come from nowhere. Your mic is on, and then it interrupts the whole procedure and process. So you ask your questions before. I'll ask him. We'll discuss about it. Then I will upload the video on my YouTube. Then you can watch it from there. That's what I meant. So for my criminal litigation, I used this. And I use this, and I've told you how I use them during my externship. When I'm reading a topic for my externship, this is what I read for the externship. So this now gave me a detailed explanation. It's time, right? There was time to read it. And once you've read it once, and you've understood it very well, you will now fall back again to your notes. Now say, yes, do you understand? You fall back again to your notes. You've gotten your proper explanation from this one, and you fall back. Then for this thing, I used I'm using it to hold this phone. This is what I used. Day one. Civil litigation. I used my day one on civil litigation. In short, that was the only book I used. That book is too superb on civil litigation. Bastardly superb. I didn't need any other thing. Basically, this book, this demo on civil litigation, was the only thing I needed, and it gave me my mark. Then for you see, the one that confused, that is the most confusing, is corporate. Corporate no get head, no get tail. Everybody they confuse each other for that corporate. Olowo Noni, because I bought Olowo Noni. Olowo Noni we say A, Badmus we say B. Which other book that by itself? There was one other. This guy Osamolu we say A, B, C. It was so confusing, especially the procedure. What's the procedure to change from private to public? This one will name something, one thing in the procedure. You find that thing. Let's say Osamolu says something. You find it in Olowo Noni. Olowo Noni did not say it. You're like, okay, in the procedure that I want to learn, like you're writing your notes for your procedure to change from private to public. Would I add this thing? Then this is how you solve it. You go to Kama. In short. God. I too love Kama. I didn't love it initially. See that first 3 months, I wasn't reading Kama. I was reading textbook. That's the definition. That's the first step to failure in corporate law. Reading textbook. Use it to substitute your Kama. I don't say don't read textbook. Textbook will help you explain some things, right? But you see that Kama, especially when it comes to procedures, my dear, read it. The questions that they are going to ask you in your MCQs and the question that they are going to ask you in your exam is Kama. They are not going to ask you a textbook. They will ask you Kama. So I carried my Kama like this and I read. So if there is a problem, right, I go to the Kama, I read what the Kama say. Then when I now don't understand what the Kama says, then I will now go and meet my lecturer. Lecturer, my head wants to scatter. Can you please explain to me, what does this mean? What does this mean? Then she will not. Even sometimes, even the lecturers themselves, they will tell you that this thing is confusing. They will tell you that it's confusing. So when it comes to the procedure, look, there are some procedures that once I saw that the 3 textbooks that I have agreed on the procedure, then I would take the procedure as it is. And I will also, you see that handbook was useless when it comes to procedures. Then if I now see that there is a discrepancy between the procedure of textbook A with the procedure of textbook B, I go to Kama. Then when I see that Kama the English that Kama is using is such that he's increasing the confusion. And I'll go to lecturer. Please don't increase my confusion. Give me a solution. Then the lecturer most times will explain to you that okay, this. Do you understand? So that's what I did. So for my corporate law, I would advise you use the textbook that I recommended, right? Read them. There's a reason for reading them. It's going to give you better understanding. For what is it called? For property, I used Dadem. I didn't use Dadem. I used Dadem because they said use Dadem. So at the initial point, I was using Dadem. And at some point, I started using class notes and I was using Fumi's notes. Fumi was a girl that had first class she's from Inlag, so I used some of my notes. At some point I had to stop using her notes because some changes and all that. So, but you get the gist of what I'm saying, Sha. So, I think that's that. And then for ethics, I use the Obi Okoye. That's what everybody uses. Obi Okoye explains very well. In short, it's perfect for ethics. Now, you said, do you repeat past questions regularly? My dear, there is a point that you get to. Past question shall be your best friend. You shall know past question and past question shall know you in law school. But the only thing is that reading past questions from the beginning is advisable, but it's stressful because it can begin to give you anxiety when you look at the question and you're not able to answer it and you're like, hey, Jesus. But I would advise that you start reading it from the beginning. Now, this is the reason why you are reading past questions from the beginning, so that you can understand the mentality of law school. Law school has a mentality, how you answer questions. I'm going to treat how you answer law school questions in another class. That's another mentorship session. So like I said, this is going to be a regular thing, so that you can understand. So how you answer law school questions could be another session entirely. I don't know what I'm going to teach this to yet, but I'm going to upload it on my status. Sir, please, is it possible to get the list of books that helped you? I'm unable to pick the names. I already said them now. I go pick the name. The law school. Okay, be like you know the law school. If you're in law school, you know the names I'm calling now. Agaba for criminal and civil litigation. Dewan, Bombay and Dewan for civil litigation. Agaba and Afolayan for criminal litigation. Then Osamolu, Olowononi, and Badmus for corporate law and practice. Then Dadem. There's this other book that they recommended in Bayonsa that had a green cover. I didn't buy it, but someone showed me, and that book looked good as well. I think the lecturer is in Bayonsa, but Dadem is the general one. And but I use class notes for Dadem. And what's the last one? Obi Okoye for ethics. Basically, those are all the books. So if there are any questions, please let me know. Like the question you're asking, you repeat past question. I was saying that yes, I repeated past questions initially from the beginning. I wasn't repeating past questions, rather. I wasn't repeating past questions. I just, it was depressing when you are in week 8 and you are reading past questions. You're like, hey, what's lele? Which one is this? What can be this? I don't know how to draft this one yet. Wait. Emma Femina hypertension. Let me read it. But no. You are learning past questions not because you want to know how to draft it at that point. You are learning it because you want to know that these are questions that are frequently asked. And these are places that I'm supposed to focus on. Let's say, I think by next week, I will talk about strategies for extension, right, by next week, so that I can talk about past questions very well. Because past question is 90% of your extension period. In short, they will say pleadings like this. Pleadings came out this year. This question, this notorious question. I know the question. This question where they said, they will say charges. OT draft charges. In short, your name is Mr. Charge. You drafted a lot of charges. Past question by extension period. You would have finished it. Finish it over and over and over again by extension. But it is not at the beginning. It is not that why is my light going off? So I guess NEPA has done its thing, and there's light apparently, but there's no light here. So I'm sorry. This is the point where I'm going to log off. You can hear me, but you cannot see me. So I'll see you guys next week. It has been a very wonderful session. Somebody said, "Is the textbook from Bayelsa Company Law?" Me, I don't know this one that you are saying. I don't understand the question that you asked. I'm talking about property, not company law. So, like I said, I have to log off now. It's 1 minute on the 1 hour rather on the dot. I think we're even past 2 minutes. They've taken light. So this is a discharge by frustration under contract law. The ability to continue this class has been frustrated. Therefore, we have to end the class at this point. So yes, I'll see you guys in next set of mentorship classes. I hope that you enjoyed this. See you in next class. Bye.